Mr. Hall.
There are just one or two further bits of evidence I need to take the Lordships to in relation to ground 1, but which also relate to grounds 2, 3 and 4. And then after that, I would hope that the rest of my submissions will be just that, rather than analysis of the evidence. So, could I ask your Lordships, please, to turn to the December application bundle again, and look at the transcript of Mrs. Kay's evidence at page 134. Now, I'm conscious I took you to this transcript before, not to this part, but that was for a different purpose. 134A at the top, in answer to a general question from a learned friend about the advice that she was given in 2008-2009 after the settlement. The answer was, my understanding is I ended up with a result that I was frustrated with and tired of dealing with, but I understood that it was correct. As much as I wanted to reopen something, I didn't know I had to go and do any more evidence tracking, etc. There's nothing more I could do. I had nothing more to give or to find. And then my learned friend asked some questions about divorce and so on. And I'm sure he can take you to those answers if he wants. But in my submission, what's said at A there properly encapsulates the appellant's attitude as at late 2008, early 2009. And then over the page, at page 135, in the middle of the page, my learned friend asked, you did not say to Mary Kay then, or indeed at any time, look, I think you got this wrong. This is at E. I'm very concerned you did not do X or Y or Z. Didn't have that kind of conversation with her, did you? And the response was not after the event. During the divorce I did. I kept asking, could she read it? It was always about too expensive. I think my lord was referring possibly to this passage earlier. And then, slightly further down, question, this moment when you go back to the solicitors in 2008 and 2009, the question was, gee, you never said, look, Mary, it's not easy for me to say, but I think you didn't provide a proper service in this respect, or that respect, or any other respect. And the answer was, no, I didn't. I didn't think she hadn't. So, again, sorry, at the bottom of the page, I wouldn't have questioned her for me the entire situation I was in because of my ex-husband, not because of Mary Kay. So that was the evidence before the judge. And I'm sorry, there's one more passage at 166.
But just further up, she does say that you did not say to Mary Kay then or at any time, look, I think you got this wrong, I'm concerned you did not do X or Y. And the answer is not after the event, during the divorce I did. Yeah. I kept asking, could she read it? And it was always just about too expensive.
Yes. I think, my lord, that may have been the part you were alluding to earlier. And that my lord's also mentioned that there was an emphasis on cost. The last passage I want to take you to is at page 166, please, which is where my learned friend finishes his questioning of the appellant at D. And he says in his question, what it comes down to is this, is it not, Miss Kay? You stand back from all this, you throughout felt that settlement was unfair. You have throughout had a sense of gnawing injustice. You have throughout known or certainly believed your husband concealed assets, manipulated financial information, and you've known throughout the solicitors did not investigate in the way they might have done. And the answer was, well, I thought they could have done. I didn't know whether you can.
What you might call a compound question to which you get an answer to one aspect of it.
Indeed, my lord. It's a very long question. And the next question was, you thought they could have done. You did not know the details of what they could have done, but you thought that they could have done. You could have looked at the Sussex side of the settlement, whether the solicitors got something wrong in 2009 through 2013. And she then says, I didn't even think the solicitor got anything wrong, though. Question, but you've looked into it. You could have looked into it to see whether there was anything in your sense of injustice and unfairness, anything that could be done about it. And she said, In response, the appellant said, I tried, I sent Miss K information and the PA. I tried and was getting nowhere. I went to the library, I tried the internet, just articles coming up in news items, newspapers, and I tried anything, but it just wasn't going anywhere. So, I think I've now taken your lordships through all the relevant, what I say in the relevant passages there. Returning to the judgment, if I may, briefly on ground 1. Core bundle, tab 5, paragraph 146. I think I've actually already taken you to 146. So page 82, so I'll... now, paragraphs 147, 148, the judge deals with Whitcomb and the case of Forbes. So I'll return to that in grounds 2 and 3, if I may. But in paragraph 149, the judge continues his analysis of actual knowledge. And my submission about finding that Miss K had actual trigger knowledge by June 2009 would be at odds with the advice given to it after the date of the settlement, which is the submission I've been making to your lordships today, effectively. Said the effect of that advice was to dissuade her, that's the appellant, from considering matters further. The judge said, for the purpose of section 14A, this detracts from the need to focus upon what that unchallenged later advice reveals about the earlier advice, which is the basis of her claim. The very nature of the later advice, discouraging as it was in relation to the likelihood of success on any attempt to revisit the settlement, was such that it raised a suspicion about the soundness of the earlier advice. Her then realisation that she was probably stuck with the terms of the settlement gave her the cause to consider the reason for her predicament might lie in the negligence of the firm she now alleges. The position was akin to the patient in Forbes who knows the medical treatment has gone wrong. She knew enough for her to begin investigating whether or not the firm was at fault. If I may, I'll deal with Forbes slightly later because it comes into the rest of the analysis about Whitcomb. But just pausing there, the central part of this finding is the middle section. The very nature of the later advice was such that it raised a suspicion about the soundness of the earlier advice. Well, I hope I've demonstrated why in my submission that isn't correct, and that the later advice is really going to other issues to do with the new assets and also to do with the downturn in the financial climate, and was not in any way focused on the possibility that further investigations earlier and or the NSMO would have made a difference. So,
You have to say, presumably, that the last sentence of paragraph 149 is wrong.
yes,
If it's wrong, is it wrong in law or wrong in fact?
well, it's this evaluation of the facts point that my own friend helpfully draws out in his skeleton at 41, which is to say that, and it's hard to tell from the judgment actually, because the judge had before him all of the matters that I have put before your lordships today, and his application of the law to that was to say that that was enough to effectively trigger her actual knowledge. So that's an application of the law to the fact, but it's not. It's a mixture of law and fact, I think, is the answer to your lordship's question. Either the judge has not taken into account sufficiently what the facts actually were, or he's got the legal test wrong in the sense that the facts do not support actual knowledge of attributability of the damage to the acts and omissions of the respondent in terms of the advice given in late 2008 and early 2009. So it's a bit of a mixed question of law and fact.
I've got a different problem with that paragraph. He starts off, I wish he hadn't used trigger knowledge. The word required knowledge would have been perfectly adequate. But the actual knowledge, and then the last sentence seems to be looking at the 14A10 question, which we've labelled constructive knowledge.
Yes, and and in fact, one of my submissions on grounds 2 and 3 is that the judge has elided two concepts in that very sentence of paragraph 149 of his judgment. And I'm going to take your lordships to force. So I think I've now dealt with, as far as I can, ground 1. In the course of answering your lordships' questions, making my submissions. May I turn to grounds 2 and 3, please? So we've had a look at the Court of Appeal's decision in Whitcomb, but we haven't yet discussed the facts of Whitcomb. Whitcomb, at first instance, obviously deals with those facts and is at tab 11 in the authorities bundle, which is page 182 in the authorities bundle. But in the interest of time, I'm going to summarise the facts, and then take your lordships to the relevant paragraphs. So, Whitcomb is also a professional negligence claim, but arising out of negligent conduct of an underlying personal injury claim rather than a divorce and serial relief claims was the case here. But despite that factual difference in my submission, and this is the fundamental basis of grounds 2 and 3, this is a Whitcomb case, and there is no proper basis upon which to distinguish Whitcomb in this case in terms of actual knowledge. Mr. Whitcomb suffered serious leg and foot injuries in a road traffic accident in 2002. He instructed the defendants in that case. There was assessment meeting. They admitted liability. There was assessment meeting in December 2009, where they agreed to pay him £150,000 in full and final settlement of his claim. Subsequently, his symptoms worsened. In January 2017, he was advised that the first time the best treatment for him would be amputation of his right foot, leg below the knee. He had the operation in July 2017. Proceedings commenced in December 2019, and central allegation was the defence being negligent in settling the claim because they failed to make sufficient provision for the risk of future deterioration, including the possibility of having to undergo an amputation. The two specific allegations of negligence were failing to obtain a medico-legal report from a plastic surgeon, which would have highlighted the risk of a need for future amputation, and failing to advise Mr. Whitcomb to seek an award of provisional damages. So, pausing there briefly, not only is Whitcomb on its facts similar to this case in my submission because of the similarity of the remedy that wasn't advised about being provisional damages in Whitcomb and the NSMO here, but also there was an element of investigation which had not been recommended in Whitcomb, and of course here part of the allegations here were there was failure to pursue investigations in relation to Mr. Mahan's assets and so on, including getting a forensic accounting report. So, when he attended his settlement meeting in December 2009, he was advised that the settlement was being offered on a once-and-for-all basis, and if after surgery to remove metalwork it was discovered he had more serious injury, he cannot recover further damages. He did not wish to delay settlement or seek a stay pending further surgery, because he did not know when any future such picture could emerge and wanted the certainty of settlement. So he was advised, as I mentioned earlier, that this would be a clean break, and even advised that he could not recover further damages, which might suggest that might otherwise be a possibility, although they didn't advise him about the existence of provisional damages. Mr. Whitcomb said that he didn't have knowledge until January 2017 when he learned of the need for amputation. The defendant said that he either had actual knowledge under section 14A at the time of the settlement in 2009, or alternatively in mid-2016. So more than 3 years before the issue of proceedings. My lords, I don't know if your lordships are familiar with the rules on provisional damages. One of my lords is shaking his head and another is nodding his head. So I perhaps better just quickly refer to them. They are, although there is a statutory basis, the rules are contained in CPR 41.1 and 41.2, which, if the lordships have the white book.
We will have a white book, but it won't be enough. No, but this one is relatively up to date. That's unusual. No, I haven't got a volume 1.
I've got 2 volume 1.
Thank you very much. So I'm back to a 2022 one, but I don't see this makes a lot of difference.
But I can't give you a page reference, but I don't think the provision's changed.
No.
This is at 41.1, my lord.
Yeah.
So 41.1, rule 41.1, 2C, an award of provisional damages means an award for damages for personal injury under which 1. Damages are assessed on the assumption referred to in the Supreme Court Act or the County Courts Act, Senior Courts Act or the County Courts Act, that the injured person will not develop the disease or suffer deterioration, and 2. The injured person is entitled to apply for further damages at a future date if he develops the disease or suffers the deterioration. And then at 41.2, which gives the criteria and process, the court may make an order for an award of provisional damages if it's claimed and they're satisfied that the acts apply. And then 2, an order for an award of provisional damages, A, must specify the disease or type of deterioration in respect of which an application may be made in the future, at a future date. And then over the page, must specify the period within which such application may be made, and there can be different periods for different types of deterioration or disease. And the claimant at 3 may make more than one application. So that gives your lordship's characterisation of an order for provisional damages, which is slightly different to nominal spousal maintenance order as explained by Mary Kay in evidence, but not materially different from my submission for our purposes. If we could turn back to Whitcomb, please, I'd like to take your lordships to various passages to explain what the arguments were by the defendants in that case and how Mr. Justice Bourne dealt with them. So, could I ask your lordships please to look at page 194 in the bundle of authorities. At paragraph 50, so these are the defendant's arguments. So for the second defendant, Troman, addressing on the 2 components of section 40A knowledge, that's to say knowledge of the relevant damage and that damage was attributable to the defendant's relevant act or omission. As to the first limb, Mr. Troman correctly reminded me it's essential to make a precise and careful identification to decide when the claimant acquired the relevant knowledge. He observed damage described in different ways at various points in the pleadings and skeletons, and invited me to summarise the damages consisting of the fact that the claimant did not obtain an order for provisional damages which would have protected him in respect of various further serious symptoms. The relevant symptoms are identified by the claimant sisters in a draft wording for provisional damages order supplied in response to the Part 18 request. I don't think I need to read that out. So that's what Mr. Troman, the second defendant, said. Now, paragraph 59 over the page, my lords. According to Mr. Troman, knowledge of future risk of further damage was all that was required in the present case, because the claimant also knew that he had entered a full and final settlement in which he was not protected against such risk. I'm obviously skipping through a few passages, but I hope I'm doing justice to the decision. Over the page, at paragraph 63, you'll see that my learned friend today was counsel for first defendant. Adopted the position taken by Mr. Troman, though his client's defence had put a date of knowledge at about March 2011, when surgery to remove metal work was not entirely successful, or September 2015 when he complained of worsening pain, or in September 2016 when he was referred to Mr. Kang, who was the surgeon who ultimately told him he needed the amputation. Jumping down to paragraph 66, I asked Mr. Wilson what it was that would reasonably have caused the claimant to start questioning the advice he'd been given. He said that it was the knowledge that his condition was significantly worse than anticipated, that he had not been compensated for that. By mid-2016, he said, the claimant's situation bore no sensible relationship to the picture painted at the moment of settlement. That, in his submission, was the latest point by which material facts knowledge had been required. acquired, I'm sorry, and just pause there. In this case, material facts knowledge is knowledge of damage. As to the second limb of section 14A, Mr. Wilson compared this to a case of bad investment. By mid-2016, he said, events have demonstrated to the claimant that his condition is much worse than anticipated and he has no compensation for it. That gave him reason to investigate why he was in this position. Had he done so, he would have found out the possibility of provisional damages. At the time to start running, he did not need to know the fine detail of what had gone wrong. So those were the arguments of the defendants in a nutshell. The judge's decision is over the page at 197, this discussion, and at paragraph 73, he identified the damage. So the damage, in my judgment, consisted of the claimant being left with a full and final settlement which made no provision for the possibility of a serious deterioration in his condition in the future. Now, pausing there, that is the central part of the damage in this case. It is a full and final settlement which made no provision for the possibility that my client, the appellant, might need more by way of maintenance, and indeed that Mr. Mahan, her ex-husband, might be able to provide more. At 76, and the judge said at 74, I should say, I'm sorry, Mr. Whitcomb knew of that fact when the settlement agreement was reached in December 2009. He'd repeatedly been advised there was a risk of undersettlement. Therefore, from then on, he knew the damage existed. At 76, then, by mid-2016, the claimant probably had knowledge about the damage which satisfied that precise test, which is discussed at 75. There was the risk not only that there was a risk of undersettlement, but also the risk was eventuating because of his continuing medical problems. But this is the critical passage, my lords. At 77, however, in my judgment, that is not when he acquired knowledge that the damage was attributable in whole or in part to the act or omission which is alleged to constitute negligence. So, just pausing there, this shows, in my submission, that the fine line can be trodden, whereby a claimant can have knowledge of damage, but not attributability, and that's precisely the situation we say the appellant was in here. Notwithstanding that they know that they have been, as it were, undercompensated, that it does not automatically follow that they should attribute that undercompensation to the acts and omissions of the professional advisor. So over the page at 79, in a case of this kind, there will not be knowledge of the kind referred to in 6b and 8a, which is the attributability. And time will not start to run until the claimant has reason to consider the advice he received may have been wrong, or that any advice which was not given should have been given. As in Hayward, the essence of his claim against his lawyers is not that advice was given, but that flawed advice was given. His case is that positive advice that the settlement had to be on a full and final basis was flawed because there is an alternative provisional damages, and that the omission to tell him about the alternative was flawed because that alternative was relevant to his personal injury claim. And 81, that the defendants were eliding the two requirements of 14A6, damage and attributability. In my submission, that is what has happened potentially here. So the Court of Appeal, as we know, upheld Justice Bourne's judgment. So what did the judge say in our case? Go back to the core bundle, please. Where have I put that? Sorry, my lord. Find.
Is it material that Whitcomb was expressly a case on actual knowledge, not on constructive knowledge, which is a point made in the Court of Appeal judgment?
My lord, yes, in the sense that I can't rely on it in relation to constructive knowledge. My sole point on that is the Gosden Halliwell Landau point, which is that the appellant was entitled to revert to Mary Kay for further advice.
Yeah.
So, the judgment in relation to Whitcomb That's page 82 in the core bundle, paragraph 147, the bottom. I therefore do not accept Mr. Hall's submission that Miss Kay's ignorance of the availability of an NSMO puts her in the same position as the claimant in Whitcomb. Post-development assessment developed in that case was such they revealed what in effect had been, at the date of assessment 8 years previously, the existence of a further latent damages claim in respect of his personal injuries. I put it like that, recognising such phraseology might not pass muster with personal injury lawyers. To contrast that overlooked claim in Whitcomb, one that could have been addressed by the assessment, at least in terms of a provisional remedy for it, but when the factual basis for one arising was expressly contemplated by the lawyers, with Miss Kay's position in 2008. Miss Kay's claim was a single non-composite one. By its very nature, any compromise would reflect the position of both parties, but most materially Mr. Mahan at the time of compromise. So, pausing there, the judge in our case seeks to distinguish Whitcomb on the basis of Whitcomb apparently involving a further latent damages claim, and in our case, Miss Kay's claim being a single non-composite one. But I've just taken your lordships to the provisions of CPR 41.1, 41.2 and Whitcomb itself, and it's quite clear in my submission that the provisional damages order that could have been obtained in Whitcomb was part and parcel of the same single claim that Mr. Whitcomb had, and it was simply a remedy within that claim. So in my submission, that is a distinction without merit in the judge's judgment in this case. In paragraph 148, moving on in the judgment, the judge said, this is at page 83, for the purpose of knowledge of attribution, therefore, there was no overlooked claim of a kind that only materialised and came to Miss Kay's attention much later. Well, as I've outlined, it wasn't the case of an overlooked claim in Whitcomb. In Whitcomb, Mr. Whitcomb was positively advised by his solicitors that there might be a deterioration in the future. He wouldn't be able to claim further damages, but that settlement now was the, as it were, best option. So there is no overlooked claim. There is advice about having effectively a clean break in Whitcomb. And the judge then used that, in my submission, inaccurate characterisation to go on to say if an aspect of her single anterior relief claim was overlooked by the assessment, the terms of it should instead, or in addition, have anticipated Mr. Mahan's financial position might improve significantly over time. That oversight was obvious to Miss Kay by June 2009. By that time, she'd been advised there was no scope for further recourse and appreciated the full impact of a clean break. She couldn't go back for maintenance payments. And the judge goes on to say, a few lines down, in my judgment, Miss Kay's position in 2009 was closer to the situation envisaged in Forbes and Wandsworth Health Authority. Knowing what she did, she was then at the stage of deciding whether to conclude the finality of the settlement was just one of those things, which she had to accept, or instead to investigate whether she was in that position because something had gone wrong with the legal advice she had received. Now, this is the part of the judge's judgment which deals with actual knowledge. But as my lord has just, I think, referred to in earlier questions, Forbes here is talking about constructive knowledge, and so two concepts have been elided. And Forbes is in the bundle of authorities. If I could take your lordships to that authority. The page should be at page 36 in the bundle of authorities. My Lords, I'm sorry, I should have just taken you on to paragraph 149 in the judge's judgment before we look at Forbes. Can I ask you to look back at the judgment, please?
Yep.
Page 83. We've already looked at this paragraph briefly, but at the end, the judge says her position was akin to the patient in Forbes and Wandsworth, who knows the medical treatment has gone wrong. She knew enough to begin investigating whether or not the firm was at fault. So it's the same point made again, really. So in Forbes, Forbes actually starts at paragraph 31. So Forbes is a medical negligence case rather than a solicitor's negligence case. Your Lordships can see that in 1982, plaintiff's leg had been amputated following two unsuccessful bypass operations. In 1992, when he received medical advice that the amputation was attributable to an omission to perform the second bypass operation earlier, he commenced an action for damages for negligence. So in that case, it was a personal injury claim, and the claimant, the plaintiff, needed to rely on section 14 of the Act. And section 14 of the Act can be found, my Lords, at page 36 of the bundle of authorities set out by Lord Justice Stuart Smith at C, page 36. And your Lordships will see that it is in materially identical terms to section 14A of the Act, and indeed my research, my learned friends' researches show that the Latent Damage Act 1986, which brought in section 14A into the Limitation Act 1980, contained effectively ported across these provisions from section 14. So it was in order to provide an alternative limitation period based on date of knowledge for economic loss claims, the same model was adopted. Section 14.1, date of knowledge, references to a person's date of knowledge in the primary limitation period of 3 years. References to the date on which he first had knowledge of the following facts: A, that the injury in question was significant, and B, that the injury was attributable in whole or in part to the act or omission which is alleged to constitute negligence or breach of duty. And as per section 14A9, for our purposes, knowledge that acts or omissions did or did not, as a matter of law, involve negligence is irrelevant. And then at 3, further down at E on this page, for the purpose of this section, a person's knowledge includes knowledge he might reasonably have been expected to acquire from facts observable or ascertainable by him, or facts ascertainable by him with the help of medical or other appropriate expert advice. So that is mirroring section 14A10 in the Limitation Act, and then also mirroring the proviso to that subsection, but a person shall not be fixed under this subsection with knowledge of a fact ascertainable only with the help of expert advice, so long as he's taken all reasonable steps to obtain, where appropriate, act on that advice. So, that's the provision that the Court of Appeal was dealing with in Forbes. And at page 41, oh, I'm sorry, at page 40, at G, it said, in many medical negligence cases, the plaintiff will not know his injuries attributable to the omission of the defendant alleged to constitute negligence. And then further down, the fact that in such case it may be necessary for the plaintiff also to know of the negligence before he can identify the omission alleged to be negligence is nothing to the point. It does not mean he falls foul of the closing words of section 14.1. For these reasons, I consider the judge was correct in holding that there was no actual knowledge. Now, I've obviously skipped through much of the details, but the point I wish to make is that it's on Judge Russon in using Forbes as a basis for saying that this appellant was in the same position as the person in Forbes for the purpose of actual knowledge cannot be right, because in Forbes, the Court of Appeal considered that the judge at first instance was correct that there was no actual knowledge. What in fact happened in Forbes was that the claimant was found, or the plaintiff was found to have constructive knowledge. And that can be seen over the page at 41. And at page 43, we can perhaps come back to those passages if we need to, but at page 43G, the court came to the conclusion in the circumstances. I'm sorry?
423G, did you say?
43G.
43. Oh, I see, yes, I'm sorry, I'm jumping between the numbers.
I've come to the conclusion, therefore, in the circumstances of this case, the deceased did have constructive knowledge. That knowledge could not be attributed to him immediately after he came out of hospital. Take time to overcome shock, take stock and seek advice, about 12 to 18 months. So Forbes was actually a case in which the plaintiff was found to have constructive, not actual knowledge, and the judge's reliance on that case, for these purposes in our case, is wrong. There is also a key difference between this case and Forbes. In Forbes, it was obvious that the doctors doing their best may have been negligent, and the predicament could be attributed to their acts or omissions. In this case and in Whitcomb, we would say that is not the case. Although my client thought that Mary Kay had done her best, she didn't think that Mary Kay had let her down and had no reason to attribute her situation to the acts or omissions of Mary Kay. So, final part of the judgment in this case, which relates to the analysis of Whitcomb, is paragraph 150, if your lordships could look at page 83. Which is where the judge says, to suggest, in my judgment, to suggest that such investigation was not prompted by what she then knew, because she was not aware of the option of something called an SMO, is to rely on a point of detail within the wider point that there could be no further recourse to Mr. Mahan on any basis. That level of detail is not what the test in Hayward requires. To my mind, the suggestion also comes close to saying that because Miss Kay did not know about an SMO, she did not then know the true nature of the firm's negligence. But in my submission, that cannot be right. Or if that is right, then Whitcomb must have been wrongly decided, because in Whitcomb, the claimant was advised there might be a future problem. The claimant was advised this settlement's on the table, and this settlement will be final if you enter into it. What was missing was indeed a point of detail about the provisional damages order. And in my submission, you cannot properly distinguish Whitcomb from this case on the basis that the NSMO is simply a point of detail. There is a further point actually at paragraph 151 in the judgment, where the judge makes an additional point which appears to shore up his finding of actual knowledge, alternatively constructed knowledge in 2009, where he says, as I mentioned below in relation to what would have been my finding in the absence of trigger knowledge in 2009, the unwritten and informal nature of the advice which Mr. Morgan says was given to him by Miss Edmonds about the firm being potentially liable, in my judgment, illustrates the point that knowledge that the settlement could not be reopened is inextricably bound up with the relevant trigger knowledge under Section 14. The advice later obtained in 2020 confirms the second was the corollary of the first. So what the judge appears to be saying there is the fact that Miss Edmonds felt able to give very informal, off-the-cuff advice that there might be something to look at in terms of negligence of the respondent is somehow relevant to either the actual constructive knowledge of my client. But in my submission, that's nothing to the point really, because Miss Evans clearly is a specialist barrister, and the explanation of the informal nature of the advice, if that even matters, which in my submission it doesn't, is that she was in fact herself regularly instructed by Martineau Johnson or their successor practice and didn't want to put the advice about potential negligence in writing.
Sorry, where did you get that from?
That was in the evidence of Mr. Morgan, and which wasn't challenged, and I think the judge made a finding to that effect earlier in his judgment. I don't think that's in dispute. That's what she said. No, it's not. My learned friend tells me that's not in dispute. That I'm afraid I can't find the reference now, but it's not in dispute that that was the reason that Miss Edmonds gave for her giving the advice by telephone rather than in writing. I can endeavour, through my learned friend's wishes, to find a reference for you.
Well, don't worry if it's not in dispute. But, I just thought it's perfectly normal if you're going to you'd be asked to advise on one point, but you need to say somebody may have been negligent to do that separately. Doesn't mean it's off the cuff, which I think was the word that you used.
Well, the reason I used that phrase was because Judge Russon relies in his analysis on the unwritten and informal nature of the advice given by Miss Edmonds.
Right.
So, when
104 might help you.
104.
Page 75.
I'm very grateful for that friend. Well, I think that just confirms, I'm grateful for that, but I think that just confirms at page 75, 104, that it was the unwritten advice accompanying the formal advice, which Miss Kay relied on the source of her trigger knowledge. The point I was seeking to make, but perhaps not very eloquently, was that the judge equates almost appears to, but it's hard to understand, almost equate well, it's so obvious that the firm may have been negligent, way in which Miss Edmonds may have delivered her advice by telephone on that point, with it therefore being obvious, and as he puts it, that the knowledge that the settlement couldn't be reopened being inextricably bound up with the trigger knowledge. But not only is the fact that a specialist barrister later said that in the way that she said it surely not relevant to the analysis of...
It's not easy to read these three paragraphs actually, but is he saying at 149 he starts with actual knowledge and then he switches to what I'm going to call 1410 knowledge at the very last sentence, enough to investigate, should have taken reasonable steps to obtain expert advice which would have helped her ascertain other facts. So that's what the last sentence is. Then at 150 he's saying you can't separate out one bit of it, the NSMO, from the wider bits, the investigation and so on. It was all part and parcel of the same thing. She knew enough to start investigating, and you can't subdivide or take away the NSMO and say that's separate. And then at 151 he says he's reinforced in that view, because when you ask for advice about can the settlement be reopened, the answer was no, but it shouldn't have been in that form in the first place. Is that what he's trying to say?
My lord, it may be, but it's not, as your lordship says, very clear. And he at least, because paragraph 149 obviously starts with my submission on actual trigger knowledge.
Yes, well, he clearly switches halfway through. But if that's what he is saying, that it was investigation, and you can't separate out one bit of the things that should be investigated, the NSMO from the other things, did he have other assets and so on, and he uses the way in which the council automatically linked the two together a few years later, is that wrong in relation to constructive knowledge? It's unhelpfully and clunkily expressed, but is it wrong for him to take that view?
Well, not in relation to constructive knowledge, save for the fact that my client's then entitled in my submission to rely on the proviso.
I think it comes back to the proviso all the time,
Yes.
doesn't it? I think
Yeah.
Once it's not actual knowledge, it all comes back to the proviso.
Yes, and for the record, as it were, what Miss Edmonds in fact said in her advice, and this is not disputed either, is that whilst there was lots of evidence of later acquired wealth, none of this met the criteria as was being discussed in the late 2008, early 2009 advice by Mary Kay. None of this met the criteria for reopening the settlement.
But she says it's obvious that if that's the case, the problem is the absence of a mechanism to look at things under the settlement. And what he's saying, I think, is the investigation, once it started it would have made it obvious to anyone who did the investigation that they're two sides of the same coin. And I think your real argument is the proviso.
Yes, my lord, yes,
actually.
that's right. But insofar as, my submission is really aimed at actual knowledge, insofar as any of those points, assuming for a moment that the judge wasn't switching halfway through to talking about constructive knowledge, insofar as any of those points were meant by the judge to relate to actual knowledge, they clearly can't be right for the reasons I've explained. So, I mean, what's in it? We don't have a record verbatim of what counsel actually said, but the evidence of Mr. Morgan, which I don't think is challenged on this point and is recorded in the chronology, which is also agreed, although I don't, to be fair, I think the defendant accepts now, the respondent accepts these were the precise words because no one knows what they were, but what she said, to paraphrase, was the real culprit here was Shakespeare and Martineau. We should consider a claim against them in negligence. So whether that's specifically because there is no NSMO or whether it's some other aspect is obviously not entirely clear.
I know this isn't your judgment, but I am a bit puzzled by paragraph 151, so I'm just trying to understand what the judge would have had in mind. Is the idea, well, if you've got reason to investigate whether you can set aside the settlement, you have reason to investigate negligence as well? I mean, there's a separate point about if you do investigate whether you can set aside the settlement, will you inevitably be told that there's a question as to negligence? But that seems to be a distinct issue.
Yes.
So where in the judge's framework does the fact that they're tied together fit in?
Well, it's just not clear, but there is something earlier in the judgment which may be worth looking at, which is at page 61. Paragraph 36. So, and in fact, paragraph 35, this is where the judge first deals with Forbes. But at 36, he says, knowledge of attribution does therefore require knowledge of facts which is sufficient to prompt investigation into whether or not the defendant was in effect at fault. Although it's clear that the requisite knowledge is of facts which indicate flaws or inadequacy in the advice given, and see section 14A9, the ability to categorise as negligent being irrelevant, questions will sometimes arise about the claimant's ignorance of an alternative course of action available to him at the time that advice was given. The receipt of apparently sound and reliable advice from the defendant might mean that only much later, even by reference to the quite general level of trigger knowledge, that he becomes aware that the damage he already knows about may be attributable to the defendant negligently failing to alert him, at that time to the availability of the alternative option. So, in my submission, in that paragraph, the judge is absolutely right, respectfully, in his description of the law, and in particular of the difficulty where apparently sound and reliable advice has been given by a professional, of becoming aware that the damage you already know you have may be attributable to the defendant. And it's only when you find out about the alternative option, as it were, that you gain that knowledge. So I'm not sure if that necessarily answers your lordship's question, but it seems that the judge commenced from the correct starting point in his judgment, but then fell into error by the time he got to paragraphs 147 to 151, in effectively conflating a number of things, conflating Miss Edmonds' comment that there's negligence with, which is the opinion of a specialist barrister much later instructed, rather than the reaction that the appellant should have had to the damage, which is, well, can I reopen the settlement? Answer, no. So I'm not sure.
Didn't he say something as simple as, can I reopen the settlement? No. Well, if that's the case, something's gone wrong because I'm not getting the money I should be getting. Is he trying to say that?
That is what he's saying. If you try and work out what is the second and what is the first, the second is the possibility of negligence.
Sorry, the second where?
In the last sentence of 151, the advice later obtained in 2020 confirms that the second, that is the possibility of negligence, was the corollary of the first, that is, you can't set aside the settlement. And he develops that at 156, where he says that although the one is not what he calls the flip side of the other, they are sufficiently connected for the court to conclude that a reasonable person in the claimant's position would have considered the consequence of the advice to be sufficiently serious, etc. I think that's, whether it's right or wrong, I think that's what it's saying.
Yeah.
Well, to conclude on grounds 2 and 3, in the absence of any further questions from your lordships, if, so far as we can understand it, as long as Judge Russell's analysis is correct, then Whitcomb can't be. The two are indistinguishable. In Whitcomb, he knew that he was in a bad situation. He didn't have enough knowledge to know that was attributable to the failure to get a provisional damages award because he didn't even know such an award existed. And that's the same position that my client found herself.
So on that thesis, you're isolating the NSMO.
Yeah.
And you say that's, at any rate, an act. I'm going back to the wording of the legislation. So the damage was attributable to the act or omission which is alleged to constitute negligence. In this particular respect, the omission that is alleged to constitute negligence is failing to tell your client about the possibility of NSMO.
Yes.
I'm picking up what you were saying a moment ago. You say, well, your client can't know about that because you didn't even know what an NSMO was.
Exactly. And that's in the same context as in Whitcomb, of there being other investigations not pursued and of the claimant being advised that they are going to enter into a clean break settlement.
So what other investigations in Whitcomb weren't pursued?
It was the report from a plastic surgeon.
The plastic surgeon report about,
Yeah.
yes, okay, that's all right then.
Yes. So may I now turn to ground 4? We've touched on this to some extent already. So this is constructive knowledge in relation to the period 2008 to 2009. We're slightly at a disadvantage in the sense that the judge, in my submission, I don't think this is disputed either, does not in fact address the proviso at all in his judgment in relation to the period 2006 to 2009. So I have nothing to take your lordships to in terms of the judgment itself. But this point was put, this submission was made by me to the judge in skeleton argument and in oral submissions that my client could rely on the proviso, which, as my lord says, is really what this all comes down to in relation to the period 2008 to 2009. And albeit made shortly in my skeleton, in the supplemental bundle at page 166, the point is made.
But he does attribute it, he does say that you refer to Galton, to be fair to you, at paragraph 50 in the context of 14.810. So he was alive to the fact that he was saying it. You can't be criticised for not saying it, I don't think.
No. I think what the judge at that point was dealing with, though, was in fact, although he referred to the fact that we both referred to Gosden and Halliwell Landau, that was really in relation to the point under grounds 5 to 7, which is to do with
Personal characteristics.
Indeed.
Okay. Well, that follows from the rest of the. He goes on and goes on about that actually.
Yes.
He doesn't deal with your 1410A argument specifically on the it's reasonable to go back to the solicitors that you started with.
Indeed.
Yeah.
So at page 166 of the supplemental bundle, paragraph 32, I had submitted that as the claimant consulting the defendants in late 2008, early 2009, the position is entirely analogous to the Gosden case discussed above. It was reasonable for the claimant to return to the defendant for advice and to rely on the advice she was given, namely that there was nothing that could be done to reopen the settlement. And as I mentioned earlier in Gosden, it was Mr. Laidlow, formerly Halliwell Landau solicitors, the defendants, latterly of Gately solicitors, who had given the original advice and to whom Gosden then turned for further advice after the problem materialised. So if we turn to the authorities bundle, please, at tab 10, page 163, that's the start of the judgment. Facts are dealt with in the first paragraph on page 164, appeal against the order of His Honour Judge Pelling. Dismissed a claimant against solicitors for damages for negligence. Judge held the solicitor to be negligent, failed to register a restriction, land registry to protect the claimant's interest in a contract to purchase a freehold property. And then going further down, the defendants, by response notice, challenged the judge's finding that the claimants were entitled to rely on the extended limitation period under Section 14A of the Limitation Act. So that was what it was about in a nutshell. And it's clear from paragraphs 10 and 50 and 52 that Mr. Laidlow would move to Gately, as I said. And then there are parts of this we'll come back to in relation to characteristics, as I say, but at 57, on page 179, the respondent's challenge, the defendant's response challenge to the judge's decision, really focused on whether it was reasonable for the claimants to pursue their inquiries using Gately as their solicitors. It is not, nor I think could it seriously be argued, that the claimants could realistically have acquired the knowledge necessary to bring the claim without engaging the services of a solicitor. It was submitted the judge was wrong. Relevant knowledge of material facts for the purpose of section 14A6A did not need to include knowledge of the absolute restriction. That is also untenable in my view. That goes on to deal with, I think, knowledge of damage, which is not what I'm referring to this for, but it goes on to say, at 59, Miss McQuail, in her very clear and realistic submissions, accepted that if it was reasonable for the claimants to consult Gately's, then the respondents are fixed with the way in which Gately's carried out their instructions. The judge, I think, was also right to assume they would have handled the matter in the same way had they been instructed in 2013. But critically, at 60, it seems to me the claimants did act reasonably in choosing to go to Mr. Laidlow in the first instance. He indicated he was prepared to accept instructions in relation to the trust to investigate how the property had come to be sold. From the claimant's point of view, he was in many ways the obvious choice. He had set up the trusts, continued to advise Dr. Weddle when the position changed in 2005, understanding the EPS scheme and how it was intended to operate. Over the page, he was therefore best placed one might have thought to provide the claimants a relatively swift explanation as to what had gone wrong. Not unreasonable for them to select him as their first port of call. And I mentioned, in answer to one of my Lord's questions earlier, at this point, we of course know that he was aware the restriction had not been registered, but did not disclose this to the claimants, even though it was, I think, part of his obligation to them as clients to notify them, that he could not act because they might have a claim against him. In fact, he and Gales chose not to make that disclosure as not something which should be held against the claimants. He acted reasonably in first consulting Mr. Laidlaw. So, in my submission, we're in the same position here.
And what did the claimants consult Gately's about? What was the scope of the instructions?
So it is quite complex, but it's to do with the setting up of a trust for inheritance tax purposes, and then something that happened later.
They obviously weren't consulting Gately's about whether there had been negligence.
No, absolutely
because,
not.
Then obviously they just said they couldn't act.
No, it was no.
Not 52.
52. Thank you very much. Yes, so 2015. So originally, the original consultation had been, so the breach of duty, you can see from paragraph 1, the breach of duty in failing to register a restriction was back in 2003. And then there was a sale of property in 2010. But at paragraph 52, we have what the claimants done in 2015 was to contact SJP, that was an agent, asking whether the EPS trust arrangements were still in place. And then at 30th of April 2015, that entity, SJP, confirmed no sign of the trust being unwound, suggested the claimant should contact Mr. Laidlaw at his new firm, Gately. It was at this point that Professor K made the internet search revealing the property had been sold. So she found out that the restriction they found out the restriction was not there anymore, effectively, because the property is gone. Sale of the property therefore made no sense. Contacted Mr. Laidlaw on 27th of May 2015 and asked him to act on their behalf to take what she described as immediate steps to realise the benefit under the trusts. So it was further work in relation to this property and the trusts, but in the light of the property in question having been sold. And despite that knowledge, going back to Gately's, who gave further advice and effectively didn't reveal their own potential negligence, was held to be reasonable, and the claimant was entitled to rely on the proviso. And that is what we say happened here. We've already noted that the claimant the appellant, I should say, had gone back to Mary Kay as a result of the Porsche, the company, and the insurance policy, and to ask whether anything could be done about it.
Isn't it a point of distinction that in Gosden, the finding at 60 is that the solicitors, Gately's, ought to have disclosed that there might be a claim against them, whereas I thought you accepted this morning that that was not something which Mary Kay ought to have disclosed.
Well, there's no appeal against the finding of deliberate concealment, so we are a finding of there being no deliberate concealment, I'm sorry. So we are, as it were, stuck with that finding. But as I read Gosden, it's not integral to the court's decision that there'd been no disclosure of that. The court says it was certainly not unreasonable for them to select them as the first port of call, and then we of course know that he was aware of the restriction not being registered. It was part of his obligation to notify them. The fact that he and Gately's chose not to make that disclosure is not something which should be held against the claimants. So the point of referring to that in Gosden appears to be that the claimant should not be fixed with that problem, that it's not their fault that they weren't told that the solicitor might have been negligent, and whether or not that amounted to deliberate concealment in this case, which the judge found it didn't, and you don't appeal against, it, by analogy, it shouldn't be held against the appellant here that that Mary Kay chose not to say, for example, you may wish to seek independent legal advice, or whatever it is that she chose not to say, whether or not she was obliged to disclose it.
So just sort of talking around it for a moment. The findings on deliberate concealment must mean, I haven't focused on them, I'm afraid, because they didn't seem to matter for our purposes, but they must mean that Mrs. Kay did not subjectively think that there was any question of negligence.
Yes.
Because if she had thought there was a question of negligence, that would have been different. That doesn't of itself exclude the possibility that a reasonable solicitor would have realised that there was such a question, or does it?
No, it doesn't. And what had happened by the time of the preliminary issue trial in this case was that the Supreme Court judgment in Canada Square and Potter had happened, making clear that deliberate concealment requires conscious withholding of information. And Mary Kay's evidence, which the judge accepted, was that she believed she had not been negligent at all.
Yeah.
And so there could be no question of that. But many solicitors might, in such a circumstance, in my submission, even if they didn't believe they'd been negligent, say to their clients, you may wish to seek independent legal advice, for example.
I'm still trying to understand Gosden, because you know my constant refrain, reading paragraphs without context doesn't help. But what seems to have happened is the woman set up a trust,
Yes.
and Mr. whatever his name was, Laidlaw, had advised on the trust, and that should have included a restriction
Yes.
to stop the sale. Somehow, after she moved to live with the other lady in the Isle of Wight, the thing was sold, the house was sold, and they wanted to get the money back
Yes.
from the sale. So they went to Mr. Laidlaw, because he's the guy who set the trust up in the first place. And that's why, on the facts, the judge concluded at 60, he said the claims acted reasonably by going to Mr. Laidlaw, and in circumstances that I haven't yet been able to disinter, because it was reasonable to consult Mr. Laidlaw, that meant the date fell after a particular date, presumably because they didn't. Well, I don't know why. It's hard to know whether this helps or applies to this case, because we don't know why it was reasonable to go to Mr. Laidlaw, or how that somehow solves the problem with the dates.
Paragraph what, sir?
Paragraph 60. Paragraph 69.
Well, we've just been looking at 60. But
It's just going back to a solicitor that's done the previous transaction, which should have included a restriction, and going back to her to find out whether the proceeds of sale have gone. Without more, I don't know how that helps us. They're not trying to establish a general principle that you've acted reasonably by going back to the first solicitor.
well,
Full stop.
no, and that's absolutely right, my lord. So there is the case of neither of us, I think, have put it into the authorities bundle, but Williams, Lishman, Sidwell, where a financial advisor or investment advisor is instructed, investments go horribly wrong, claimant goes back to the investment advisor and says, what's happened? And then doesn't go to anyone else. But it was so patent and obvious. Such patent and obvious negligence by that advisor that the claimant was held not entitled to rely on the proviso. So the reason that Gosden is in here is because it makes clear that depending on the facts, it can be reasonable to go back to the original advisor. And so the question for this court is, on the facts of this case, was it reasonable to go back to Mary Kay? A question which Honourable Judge Rushton did not in fact grapple with in his judgment at all. And my submission it was, because you've seen part of the reason for taking your lordships to parts of the transcript of the appellant's evidence was that she placed great trust in Mary Kay, despite her unhappiness with her situation generally, and accepted the advice that was given by Mary Kay, and indeed Mary Kay herself, as the judge recited in his judgment, considered that the appellant was very happy and satisfied with the outcome of the ancillary relief proceedings. So in those circumstances where the appellant had no reason to question Mary Kay, and where what we say is the single biggest element of negligence here, which is the NSMO, is a remedy that the claimant had, the appellant had absolutely no knowledge of and hadn't been advised on, it was reasonable to consult Mary Kay and not to go and then consult some other expert at that point.
And just, can we just relate it, or try to relate it to the wording of the provision for a moment?
Yes.
So this is 14A10. So the knowledge you're deemed to have includes knowledge that you might reasonably have been expected to acquire from facts ascertainable with the help of appropriate expert advice which it is reasonable to seek. So you're focusing on whether it was reasonable to seek the expert advice from Mrs. Kay.
Well, not quite, my lord.
Not-
So it's the proviso that follows that.
I think you've accepted that it was reasonable for the claimant
Yes.
to seek advice about her situation,
Yes.
but you then get to the proviso
Yes.
and saying that
So long as
she
you
won't
take
be
no
taken to
reasonable
have had
steps.
knowledge
Yes.
because she took all reasonable steps, which consist of going back to Mrs. Mary Kay.
So I'm not sure. It's a hypothesis that it was potentially reasonable to go back to Mary Kay, but that doesn't amount to taking all reasonable steps.
No, that does amount, my lord, to taking all reasonable steps, as it did in Gosden. In Gosden, the claimant's relying on the proviso and saying that in going back to Mr. Laidlow, they'd taken all reasonable steps to obtain and act on that advice. In this case, we're saying going back to Mary Kay in relation to the 2008-2009 period was taking all reasonable steps to obtain the advice which might, if properly given, have revealed the facts in question.
Because you say, if on the hypothesis that the solicitors had been negligent, then a fair and reasonable solicitor asked about, can we reopen the settlement, would have said, you better take some independent advice. Is that how it works?
Well, it's not just about that, because the subsection 10 B provides that, or subsection 10 provides, knowledge includes knowledge which might reasonably have been expected to acquire. So, which one you might expect them to get from B, facts ascertainable by him with the help of appropriate expert advice which is reasonable for him to seek. So, if you would expect going to a solicitor in those circumstances to reveal that there might have been a problem with the settlement, then if you fail to take any steps to go and get that sort of advice, you are, per subsection 10b, fixed with that as if you would have had that advice. So you must go and take steps. But you can rely on the proviso because in this case, we can rely on the proviso because she did take steps which were reasonable to take, which is to go back to Mary Kay, and Mary Kay did not in fact give the advice that there may have been a problem with the settlement.
The hypothesis, contrary to Mary Kay's view, is that any reasonable solicitor would look at this, any reasonable ancillary relief solicitor would look at this settlement and say, this is rubbish, it hasn't got an NSMO.
Well, yes, but it's not. I think your lordship, in your previous question, suggested that it was necessary, or that the hypothesis is that some other solicitor would say that was a negligent settlement. But that's not what one needs to look at for the purpose of the proviso. It's back to this point about what facts do you need knowledge of, damage and attributability, and whether or not that would have been revealed by expert advice. And it doesn't matter whether or not Mary Kay says, I may have been negligent. It's whether any solicitor faced with that situation would have said,
I mean, just trying to disentangle this a moment longer. Sticking with B,
yes,
before you get to the proviso, you're in trouble if it was reasonable for you to seek expert advice, which would have revealed that there was a question as to negligence. I mean, I've been putting it in crude terms.
yes,
And that could either be because you'd gone to an independent solicitor and the independent solicitor would have said, look, there's a problem here, or because you'd have gone back to Mrs. K and she would have identified that there was a question and therefore told you to go and get independent advice. And either of those would be a problem for you. So, but for the proviso, you would have been in trouble because in taking the expert advice, you could be expected to have found that there was a problem.
yes,
Hence, you're into the proviso.
my lord, yes.
And then, as you say, that says you're not to be taken to know of something which you could only have found out by taking that advice if you've taken all reasonable steps to obtain the advice.
Yes.
So if it's the same reasonableness, if it was reasonable for you to consult Mrs. K and she didn't tell you, you're all right. The only sort of catch to that would be if it wasn't all reasonable steps because you could reasonably have gone somewhere else.
Well, and in Gosden, the claimant didn't go anywhere else.
But there's a slight difference. I mean, there is the question of whom you go to for advice and what you ask them about. Gosden is different because they hadn't been the solicitors that the claimants had been dealing with. They had been the people who'd set up the trust of the mother's property, and they went to them because they'd set up the trust. And the solicitor should have told them there's a problem. This is slightly different. What has happened here is that the appellant is dissatisfied with the mismatch between what she thinks should have happened and what has happened.
Yeah.
And the argument is that she's taken, well, you've accepted that the first part of 10b applies, and she should have taken, it is legal for her to take steps to get the help of an appropriate expert. And we're working on this hypothesis that it's obvious once you ask an appropriate expert why this mismatch. These experts say, well, you can't do anything about the settlement, I'm afraid, as far as Mr. Mahan is concerned, because that's fixed and you're not allowed to reopen it. The problem comes much earlier in the chain. The settlement shouldn't be in these terms. Now, if you go to this list, if you're concerned that the settlement doesn't match what should have happened, and you A, go to the same solicitor, and B, don't ask her directly, has something gone wrong here? And C, you're not suggesting that the solicitor failed to disclose anything that she should have disclosed by way of telling her to get independent legal advice. Has she taken all reasonable steps given the suspicions that generated the going back in the first place?
Well, as I said a moment ago, in my submission, the obligation or not to disclose one's own negligence is not material. It's not part of the true ratio of Gosden, I don't think.
But it is to your case in the sense that, as I understand it, you say, well, consulting Mrs. K on whether or not the settlement could be set aside could reasonably be expected to produce the answer, you need to take independent advice. And therefore, on your case, going to Mrs. K should be enough to produce the knowledge.
Well, it's not, my lord, it's not quite that. It's not
No.
because she should have said you need to take independent legal advice. That's enough. The case is, she was reassured by Mary K that there was nothing that could be done. That was the advice that was given, and that is sufficient. Whether or not Mary K had an obligation to disclose her potential own negligence is irrelevant and not central to Gosden.
But then, maybe I'm worrying about a slightly different issue, which is it good enough for you to seek advice on setting aside the settlement? And it's only good enough for you to seek advice on setting aside the settlement if that's well, no, maybe there's a different question, but it's easier to say that seeking advice on setting aside the settlement is good enough if it can be expected to produce the answer, there's a problem.
I understand your lordship's point. When I took you before the lunch and adjournment to various passages in the communications in late 2008, early 2009, you may recall that the appellant did, in terms, say it's unfair. Is there anything, the settlement was unfair, is there anything that can be done? So she didn't simply say, can I reopen it because there is a portion of company, but obviously that was the reason that drove her there, and the judge found, and was right to find in my submission, that was the predominant reason for going back to Mary Kay, but having gone back to her, that being a reasonable step to take, and having been told there's nothing that can be done, precisely how my client put the question to Mary Kay is not in my submission material. It's about the fact that she looked to take some expert advice on the sorts of issues that were arising, and that advice was what it was, which is you can't do anything.
If the question, or if a critical question is indeed whether the claimant has taken all reasonable steps, and if that's a question which the judge has not addressed, what are we supposed to do about it? Give our own answer, or send it back to the judge? Or
Well, your lordship can, of course, give your own answer on the basis of the evidence that I've taken you to, and we invite you to do that. But your lordships would have the option to remit that issue to determination as well as potentially the impecuniosity issue. But in my submission, there is no real distinction with Gosden. I hear what my lord says, of course, about slightly different factual matrix, but in any event, even if we're not on all fours with Gosden, there is nothing, in terms of the facts, there is nothing in Gosden to suggest that there is really anything in the all part of all reasonable steps in relation to going back to the original advisor. It's really about whether or not that advisor appears to be someone you can still reasonably trust the opinion of, rather than whether or not you've asked all the right questions at that point, and whether or not they have an obligation to disclose potential negligence. I think that's all I can say on round 4.
I mean, it is a bit tricky in some ways, because on the one hand, you've shown us emails which show that Ms. Kay and Mrs. Kay seem to get on pretty well and liked each other, etc. On the other hand, the premise for this is that the claimant has been advised to enter into a settlement which she has always regarded as very bad, which she ought never to have been in.
Yes, indeed. But in that sense, we're assisted by the evidence of Mary Kay herself, which is that ultimately the appellant accepted the advice she was given and appeared happy with the result. So, and it comes back to the point about the system. So I took your lordship to the transcript where she said I was always trying to set it aside, but the system was wrong. Mm-hmm. So she never appears on the evidence to have blamed Mary Kay at that point for her predicament. She blamed what she perceived to be the system.
It's the same point, and it'll be the same answer. But just looking at 10b, before we get to the proviso, I'm trying to work through the consequences of what's been conceded. 10b says a person's knowledge includes knowledge which he might reasonably be expected to inquire. Knowledge is defined in 6 as knowledge required for bringing in action for damages. It includes 8 damages attributable in whole or in part to the act or omission alleged to constitute negligence. So when you say it was reasonably expected, the appellant might reasonably be expected to get the help of an appropriate expert.
Yes.
Who might disclose the facts that indicates damage, i.e. suffered as a result of something or done or not done by the solicitors, that might well put a different flavour on whether it's reasonable to go back to the very solicitors that have been advising you and got you in the predicament in the first place. Whether if the real problem is there's such a mismatch between what I'm getting and what I think I should have got, that it's reasonable to take advice. Is it then taking all reasonable steps to go back to the source of the potential problem? You say yes.
I say yes, and
Yeah.
I say I mentioned to you the other case, which sadly isn't in the bundle of authorities, Williams, Lishman, and Sidwell, which is where it isn't and where it is. But there is also, may I take you to Morris and Knights, please, because actually I meant to do that, and that's got a sort of higher level discussion of this. It's not an appellate authority, but it does usefully refer to various cases, including Williams, Lishman and Sidwell, which I've referred to in answer to your Lordship's questions. So, let's go back to my notes. Right. So, at page 226 in the authorities bundle, and again, I'm not taking your Lordships to the fact of this case, because my learned friend and I have agreed, I think, it's fair to say, that this is a useful vehicle for a summary of the law in this area, rather than a case that we rely on for its result, as it were, in an effort to try and keep the authorities bundle shorter, but sorry if that's not the right thing to have done, but anyway. At 78, there's the case of Blackmore's and Scott referred to as authority of the proposition. Knowledge of solicitor's error is insufficient. Claimant has to show the consequence of the error in order to have requisite knowledge. This is about the actual facts of Morris. Going down towards the bottom of that paragraph, for the purpose of section 14a10, it was reasonable for him to seek advice from the first defendants, as they appeared to be suitable experts for this purpose at the time, referring to Barker and Baxendale and then Gosden and Halliwell Landau, so that the submission was suitable experts to go back to. At 79, at the other counsel in the case, Mr. Wood argued on this last point that the original solicitor cannot be an expert for the purpose of section 14.810. Only a solicitor independent of the alleged tortfeasor can be regarded as an expert. Said that was the effect of the Williams and Lishman Sidwell case that I referred your Lordship to. And then at paragraphs 100, so this is on page 233 in the bundle, judge in this case, who was His Honour Judge Kramer, sitting as a judge at the High Court, said, I compare what was said in Williams to the Court of Appeal in Gosden and Halliwell Landau. Mr. Butler argues similarities to the current case in that Mr. Gosden went back to the solicitor, Mr. Lalo, who had drafted an estate protection scheme but negligently failed to protect the interest under the scheme by registering restriction. By this time moved from Halliwell Landau to another firm, Gately. The question as to suitability of returning to the solicitor who was said to have been negligent appears to have been raised as it was considered both by the judge at first instance of the Court of Appeal, and he then cites from Lord Justice Patton's judgment, which we have already looked at. Then talks about two other cases at 101, Barker and Baxendale Walker, one of the ones that the counsel claimants in this case have relied on. Claimant was held not to have constructive knowledge as to negligent tax advice about an employee benefit scheme, returning to the same barrister for that advice when the scheme was challenged by HMRC. It does not appear the defendant's sister sought to argue this as a basis for imputing knowledge, so that may not have been fully an issue in that case. And then in 102, Blackmore's and Scott, the appellants were held not to have section 14a knowledge. Their solicitor's negligence in failing to lodge a restriction against a manorial title with the consequence the adjudicator had discretion to refuse to close the title even if they later proved the registration was mistaken. The solicitors moving on, the solicitors who negligently failed to enter the restriction informed of the consequences of such failure acted for the appellant throughout the registration dispute, including up to the judgment by the adjudicator.
Well, paragraph 104 is really the key.
It's really the problem. It all turns on the facts.
Yes, which is what I'd submitted to your lordship earlier. So, the various cases to which I've been referred to reveal this as no hard and fast rule. And it says, sorry, going back, as to whether appropriate expert advice can be that of the allegedly negligent advisor, it's highly fact dependent. The section requires the court to consider whether the claimant has taken all reasonable steps to advise. Sometimes it will be clear it will not suffice, as in Williams. In other cases, such as Gosden, it will. So that's why we come back to the facts in this case, the relationship between the appellant and Mary Kay, and the questions that she asked, the answers that she was given, whether that is enough. And the judge in this case, Judge Russon, didn't address it. I submitted it was. I continue to submit it was, because this was a technical area of law. Whether or not to pursue lines of investigation is something that my client could not be expected to know the answer to, in the sense of how far one should go. She didn't know anything about the NSMO at all, and she didn't even know what the effect of the apparently after acquired Portion Company was until she was given the answer about that. So she was reasonable in my submission in going back to Mary Kay. And whether or not she was obliged to, the fact that Mary Kay didn't say maybe you should seek independent legal advice is something that shouldn't, the consequences of it shouldn't be visited on the appellant, just as it wasn't in Gosden.
Why didn't she go back again in 2018 then? Same problem, more information about more wealth.
Because by that point, Mr. Morgan was on the scene and was happy to help. She did go back multiple times, as your lordships have seen, at the end of 2008 and the beginning of 2009, to Mary Kay.
So if your client had identified the matter on which he needed advice as potential negligence, it plainly wouldn't have been reasonable to go back to Mary Kay.
No.
But you say it was enough that she thought it was a good idea to get advice about setting aside the settlement, and that could have been expected to produce a good enough answer. The fact that it didn't means that your client is, so to speak, off the hook.
Yes. That's the argument, my lord, yes. So I'm now going to turn to 5, 6 and 7.
Yep.
Which I'll deal with together. And I have, I think, in opening, addressed this to an extent, but what I perhaps didn't address was the chronology. Well, I did address it to an extent. I don't think there's any dispute about the chronology at all. And the only thing that is missing from the judge's judgment is this point about whether the Hildebrand bundle was actually, whether there was a delay in confirmation in 2019 from the respondent that they no longer had the Hildebrand bundle. So, apart from that issue, the judgment confirms the chronology as, I think, not disputed between the parties, that obviously the effects of consequences of the chronology are highly disputed, but in terms of what actually happened, late 2017, Mr. Morgan and the appellant begin a relationship. At the same time, roughly, she starts to see further evidence of her ex-husband's increased wealth. 2018, early 2018, she asked for her file and collected it in May 2018. January 2019, Mr. Morgan and the appellant asked for a copy of the Form E. That comes back relatively quickly. February, they asked for the Hildebrand bundle. That is confirmed not to be in the possession of the respondent by July. There is some falling out between Mr. Morgan and the appellant in late 2019, and after reconciliation, he instructs counsel in March 2020. And that, it's right to note that the appellant unfortunately suffered a number of other problems and personal difficulties during that period, but we have to accept on the authorities that those other problems like ill parents and so on are not characteristics that can be taken into account. So she says that she was, in her straitened circumstances, as we earlier noted, unable to instruct anyone else other than Mr. Morgan, reliant on him, reliant on his goodwill in terms of looking at the papers, assembling the papers, and indeed instructing counsel and paying for counsel to advise. So the law is in the Ravgard and Gosden cases and Adams, as I mentioned earlier. So in terms of what characteristics can be taken into account, again in looking at the proviso, so the question here, we're back to section 14A10, because the judge found that the appellant had constructive knowledge by the end of 2018 as an alternative to his primary findings of actual constructive knowledge in 2008-2009. So we're only concerned with section 14A10, and we're concerned again with the proviso and whether or not the appellant had taken all reasonable steps to obtain expert advice, and whether or not that, as I said earlier, involves consideration of her impecuniosity, or perhaps more powerfully, her impecuniosity as, on the face of it, caused by the negligence complained of.
And I'm getting myself muddled. It is the proviso we're worried about here, is it?
Yes, it is. Because she says, I had no money, I had to rely on Mr. Morgan. In order to get to the expert, and the expert is Victoria Edmonds, counsel who advised in May 2020. Mr. Morgan is not the expert, because he's not a family law expert, he was a commercial litigator, and he was merely the facilitator of getting the expert advice. But that was her, she says, only route to get that expert advice.
I mean, when she succeeds in taking the advice, she learns the fact.
Yes.
His proviso is not B. I mean, it's
No.
you're fixed with knowledge of things you could have found out with the help of an expert in circumstances where it's reasonable for you to seek the advice. When you say it wasn't reasonable for you to seek the advice until you had the money.
No, that's not quite it.
No.
No. We say that late 2017, the signs of wealth are such that at that point, serious questions have to be asked about whether or not the settlement can be reopened, and it's that because asking that question led to counsel advising, and this is where we come back to, in some ways, to paragraph 151 of the judge's judgment about things being inextricably bound up together, led to counsel advising that there might have been negligence, that we have to accept for these purposes, and have always accepted, that it being reasonable to seek some advice on reopening the settlement, as at 2017, 2018, and it then being something that counsel said in response to being asked to advise on that is fact, those facts of attributability, which is bound up in the suggestion of negligence, were facts ascertainable with the help of appropriate expert advice, and it was reasonable at that point to go to counsel and say, can I reopen it? The only question is, so we have to concede effectively section 10b. The only question is, can we rely on the proviso? And the way in which we seek to rely on the proviso is, she had no money, she was reliant on Mr. Morgan, that was the only way to get the expert advice, and that in her circumstances, she did take all reasonable steps to try and get counsel advice, albeit it took a period of a few years, and it took that period because A, they needed the papers, and that took some time. B, she needed the sign-off from Mr. Morgan, as it were, to pay for the advice. and C, they
You do
then
have
need
two
to
points
actually...
because you had nearly a year. I mean, I forget when he got the file in 2018. He didn't look at it until January 2019, and then you can say there was delay afterwards, which was not the fault of the appellant because they had to go back to the Form E and back for confirmation that there was no Hildebrand. So you couldn't include that 6-month period. But the judge says at 159 and 160, you should have gone sooner than you did. And I think the question is, was it a failure to take reasonable steps by not going sooner? So you'd have had the knowledge sooner. And you say, I really think it does come down to money, actually. She didn't have the money to go any earlier than she did. Because if she had gone any earlier than she did, she'd have had the knowledge at an earlier stage.
My lord, yes. So the evidence of both the appellant and Mr. Morgan, which I think on this point was unchallenged, is that he was fitting in this pro bono assistance around other professional duties and so on, and had researched whether or not there was a limitation period in respect to the reopening of the settlement. And he had concluded that there was no such limitation period, and therefore that there was, in that sense, no urgency. Because they say, the appellant and Mr. Morgan, that neither of them was contemplating a claim against the respondent. They simply wished to know whether or not she could reopen the settlement. So, against that background of not believing there to be any real urgency in that sense, and him doing this as pro bono work, as it were, on the side, it is correct to note that between May 2018 and January 2019, he did not look at the papers, or at least it took him that long to get through looking at the papers. That is, but it all comes back, my lord, to the impecuniosity point, because she was reliant on just waiting for him to deal with it. And if he said, I can only deal with this when I can deal with it, and she couldn't go anywhere else, then what other choice does she have? So that's the argument.
It does come back to her not having money to pay somebody else.
My lord, yes.
Whilst she knew that there was something to look at.
Yes.
And
So-
she decided to wait for Mr. Morgan
Yes.
and not to pay for somebody else.
My lord,
So to be absolutely explicit, as my lord says, if she hadn't been short of cash, it would undoubtedly have been reasonable for her to get advice earlier.
yes. And as my lord says, there may be some period, say between February 2019 and July 2019, where
The other side.
she can't be blamed for the delay. But apart from that period, the issue is her impecuniosity. And ground 8 is about that period, and it's, as I said earlier, it's an adjunct in a sense, because the two things go together. But the main issue is the impecuniosity. So, again, conscious of the time, but
Yes.
I'm hopeful that we can get through the authority.
I think I was over-optimistic in suggesting we'd finish in a day and a half, but at least you ought to finish in the day.
Yes. So the first authority to look at is Gravguard. I don't think I need to take you to Gosden. My own friend can take you to Gosden if he wishes, because what Gosden says is you can't take into account, on this front, you can't take into account peculiarities of the claimant like ill relative. And I don't resist that suggestion. Gravguard is at tab 7, page 81 in the authorities bundle. So, Gravguard was a professional negligence claim against solicitors in relation to a mortgage transaction that took place in 1988. And the claimant in that case was found to have constructive knowledge by the end of 1996, and so her claim issued in 2002 was out of time. So, Lady Justice Arden at paragraph 9 at page 90 discusses constructive knowledge and at the 6th line describes the proviso as the tailpiece of subsection 10. The person does not have constructive knowledge of matters which are ascertainable only with the help of experts if he has taken all reasonable steps to obtain and where appropriate to act on that advice. If, therefore, he is tenuously instructed an expert, it must be shown he had actual knowledge of the facts specified in section 14a or constructive knowledge on some other basis. This helps to prevent a claimant who acts properly from being penalised for shortcomings on the part of his expert. So in the present case, Mrs. Gravgard did not instruct the solicitor until May 1999, and it may be her solicitor was not instructed to advise her on possible claims against the respondent until some time after that. Accordingly, if the court concludes it was reasonable to seek expert advice before that date, she failed to take all reasonable steps. The effect is the facts she could have ascertained with the help of solicitors will be attributed to her at that earlier date. On the other hand, if it was not reasonable to expect to consult solicitors by then, and the solicitors could not have assisted to ascertain material facts, she would not be treated as having acquired knowledge of necessary facts. So we then turn to paragraph 17 in terms of the decision in this case. Paragraph 16, where it was contended that Mrs. Gravgard had constructive knowledge, she should have taken legal advice about her claim against Lloyds in 1988, and if not, then when possession proceedings were threatened by Lloyds in 1992. So just pausing there for a second. It was that claim, it seems, that would have led her to discover the potential claim against her solicitors. Mr. Nichols submits that just as the claim suffered several heads of damage, can't simply rely on the head of damage which is in time to claim the limitation period expired. So too, she cannot confine her case to the allegation of negligence based on the failure to advise her it's not necessary to execute a deed of gift. So on. In my judgment, Mr. Nichols' primary submission on the constructive knowledge is correct. Mrs. Gravgard knew as a result of the Lloyds transactions the property is exposed to the risk of attachment for his debts. It was reasonable to expect that she would take legal advice on her claims against Lloyds as soon as she was prevailed upon to execute the second guarantee, and so on. And then right at the bottom of that very long paragraph, the last few sentences, 5 lines up, if Mrs. Gravgard had turned to Mr. Browder for advice and the question had arisen whether the advice in February-March 1988 was correctly given, he would have had to advise her to seek advice elsewhere. In my judgment, for the reasons given above, it's reasonable to expect she would have sought that advice. So again, it's another case where it seems the original advisor might have said, go and seek advice elsewhere. But the discussion of what characteristics can be taken into account is over the page at paragraph 19 onwards. At 4 lines down, the only question under section 14a is whether it's reasonable to expect her to take legal advice and whether it's reasonable to expect Mrs. Gravgard to acquire knowledge from the facts ascertainable by her with the help of a solicitor investigating the claim against Lloyds. The test is met. And this is the critical part, my lords, where at 20 it says, there is of course an issue as to whether the court should, in determining whether it is reasonable to expect a person to seek legal advice, take into account the surrounding circumstances and any special characteristic or attribute of the claimant. Section 14a(10) is assigned as to the matters which the court must take into account and leave such matters to the courts to work out. The test, however, is clearly objective. In my judgment, the court should take into account external surrounding circumstances, such as the significance of the issues to a reasonable person in the position of the claimant. The more difficult issue is whether the court should take into account matters such as the fact that she was already had her hands full because she was a working mother and wife and was struggling hard, and as the recorder put it, to keep her financial head above water. These factors could make it more difficult for her to get advice, though as regards Mrs. Gravgard's financial position, no one has suggested that if she had sought to do so in 1988, she would not have been entitled to legal aid if she otherwise met the conditions for such assistance. Now, just pausing there, my lords, this is the bit of, as it were, obiter dicta, I described it as earlier, that I rely on. So, in this paragraph at 21, court here acknowledges that it's difficult, the more difficult issue is whether the court should take into account matters such as her financial conditions. These factors make it more difficult for her to get advice, but no one has suggested she sought to do so and would not have been entitled to legal aid. So the corollary of that, in my submission, is that had someone suggested, in this case, that she might not have been able to get assistance because of her financial circumstances, that might have been a factor that the court could have taken into account.
Suppose you read the whole of 21 and it's a classic, gosh, life is hard, but
Yes.
you don't know the end result.
Yes.
Although Mrs. Grover does not rely on these matters, a court could not fail to observe the difficulties of her position.
Yes.
Who would not fail to observe the difficulties of a mother trying to keep her home and food on the table for her children?
Yes.
But observing the difficulties
Yes.
is not the same as saying
No.
it is a matter to be taken into account. And we just don't know from this paragraph, do we?
Well, we don't know what it does say is no one has suggested if she sought to do so she would not have been entitled to legal aid. And as I say, the corollary of that is that had someone suggested that, that may have made a difference, but we don't know.
You don't know because it goes on to say it wasn't relied on, and then the court didn't have to decide it. This paragraph is a classic life is difficult paragraph.
Well, in my submission, there is something in there which suggests that the court might have taken that into account had it been suggested, but I accept, my lord, that it's not by any means concrete confirmation of that. But at paragraph 24 over the page, what was said was this: that on the basis that section 14A10 requires the court to have regard to the position of the actual claimant, not some wholly hypothetical claimant, in my judgment it's appropriate to take account of her belief that she had a claim against Lloyds. So now in that sense, that was something that was held against her because she was in the actual position of believing she had a claim against Lloyds. But it ought, in my submission, to apply the other way. It goes on to say, nor is it inconsistent with, that's not inconsistent with the objective test, nor is it inconsistent with the conclusion of the House of Lords in Adams. That case concerned section 14.3 rather than 14.8.10, but the two provisions are similar. The issue relevant for present purposes was the particular problem of applying the test for constructive knowledge to a claimant with dyslexia. The claimant's case, and this is the case I mentioned earlier I'd like to take you to, was he had been inhibited from taking advice because of his disability. This is the usual situation. The claimant seeks to persuade the court to take some characteristic of his into account so as to prevent the attribution of constructive knowledge. The speeches in the Adams case indicate the difficulties in the courts drawing a hard and fast rule for this purpose. However that may be, this case is not that situation. Mrs. Gravgard seeks to rely on it to justify leaving out of account a belief she actually had. In my judgment, there is nothing in the Adams case which should lead this court to ignore the actual belief of Mrs. Gravgard, and so on. But the important passage there in my submission, the important passages are the first part of that paragraph, not some wholly hypothetical claimant, and that the speeches in Adams indicate the difficulties in the courts drawing a hard and fast rule for this purpose. So I would like to refer your lordships to Adams, which is at tab 6 in the authorities bundle, and page 56. And as is noted in Gravgard, that the claimant in Adams was dyslexic, and the claim that had been brought against local authority that provided schooling for the claimant was in relation to their negligence in that schooling, which left him with mental health issues. So, what I'd like to do is take your lordships to each of their lordships' speeches in relation to the relevance of characteristics. So, at page 67, paragraph 39 at the bottom, if Lord Hoffman here is talking about the evolution and history of the provision that becomes section 14.3 that we looked at in the Forbes case, and which is in material identical terms to section 14.8.10, which is no doubt why it was referred to in the Gravgard case. And at 39 at the bottom of page 67, he talks about the central asbestos case and defects in the preceding 1963 Act, the worst drafted act on the statute book, apparently, and the Law Reform Committee's advice to look at it. Now, myself and my learned friend, as I mentioned earlier, have gone back to the Law Reform Committee reports, for several of them leading up to the 1975 Limitation Act, the 1980 Limitation Act, the 1986 Limitation Act, and we're satisfied, I think, that in terms of the 74 report, what's stated in Adams is all the court needs to know. Its main recommendation in relation to data knowledge, it should not be necessary for the plaintiff to know the cause of action or that the claimant had in some sense been at fault. And then at page 88A, this is the part I rely on in particular, the committee also considered at paragraph 59 of that 1974 report whether the definition of constructive knowledge should apply an objective or subjective test. It agreed the definition of constructive knowledge should allow the court to consider all the circumstances of the case, including the fact that most people do not have a legal or business-like turn of mind. And this is the critical part, and that a plaintiff may, as a result of an accident, have been rendered less diligent in the protection of his interests than he would otherwise have been. So, Lord Hoffman there discussed the legislative background. And then on page 70 of the bundle, at paragraph 49, my lords, he said this: in principle, I think the judge was right in applying the standard of reasonable behaviour to a person assumed to be suffering from untreated dyslexia. If the injury itself would reasonably inhibit him from seeking advice, then that is a factor which must be taken into account. My difficulty is with the basis for the finding that such a person could not reasonably be expected to reveal the source of his difficulties to the medical advisor. In the absence of some special inhibiting factor, I would have thought that Mr. Adams could reasonably be expected to seek expert advice years ago. So, on the facts of that case, maybe Mr. Adams couldn't rely on that. But in principle, if the injury itself would reasonably inhibit him from seeking advice, that's a factor which must be taken into account. Now, the other law lords gave slightly different, reached slightly different conclusions in their speeches. And the next one is at page 72, my lords, paragraph 58, where Lord Phillips said, the test of what is reasonable is one which is a recurrent motif in the provisions of the 1980 Act. Some, at least, of those provisions suggest the test of what is reasonable is an objective test applying the standards of the reasonable man. Thus, the reference to all reasonable steps in section 14.3b and in a similar context, section 14a.10, suggests an objective standard. The same is true of the provision, and so on. These provisions lend some support to the conclusion that standard reasonable behaviour for the purpose of section 14.3 is one which does not have regard to aspects of character or intelligence which are peculiar to the claimant. Now, in that passage, Lord Phillips doesn't deal specifically with the equivalent of the proviso, but rather the more general references to reasonable steps. Although he does say, thus the reference to all reasonable steps in section 14.3b itself suggests an objective standard. So he does deal with it. We have a few to go. So we have Lord Scott, my lords, at page 74. Which paragraph 71 again deals with the more general references to reasonableness in section 14.3, knowledge which he might reasonably be expected to acquire, and that, in Lord Scott's view, was taken as a reference to knowledge which a person in the situation of the claimant, i.e. an adult who knows he is illiterate, could reasonably be expected to acquire. So he does say you have to take into account that factor, but personal characteristics such as shyness and embarrassment should be left out of the equation. And then over at the page at 73, he refers to Baroness Hale's speech and then says that she had referred to a Law Commission report suggesting it would be fairer to plaintiffs that the test of constructive knowledge should contain large subjective elements, and that in Lord Scott's view that might well be so, but it would be fairer to defendants that the test should be mainly objective. Statutory provision for construction knowledge in the context of limitation must strike a balance between the interests of claimants and defendants. There may seem to be an unfairness to claimants in banning them on lapse of time grounds. There's also unfairness, I'm paraphrasing, to defendants in allowing actions to be brought after the lapse of time, which has prejudiced their ability to refute the claims. In my opinion, the approach, section 14.3, should be mainly objective. What would a reasonable person placed in the situation in which the claimant was placed have said or done? So in my submission, that is acknowledging that the position that the claimant finds themselves in and placed suggests placed by virtue of the situation that's under consideration in the case, i.e. in this case, impecuniosity resulting from negligence, we say. Lord Walker also talks about 77 on the same page. It's not contended by either side the correct test is wholly subjective or wholly objective. The distinction between circumstances and personal characteristics is intelligent and helpful, but they're bound to be some in which the distinction is elided, and so on. And then and he says, Baroness Hale's distinction between personal characteristics affecting a person's ability to acquire information and those affecting a person's reaction to information once acquired is a distinction that will be useful in some cases. And he goes on to say, we therefore be cautious about any simple formula put forward to cover every case. And we finally get to Baroness Hale.
And he seems to limit his judgment to the facts of this case, rather than any general statement, yes.
Yes. And then we get to Baroness Hale. Baroness Hale is quite detailed in her speech. And I'm going to try and pick out just the very key parts. At G, on page 96 of the reports, is paragraph 81 towards the bottom of page 76 of the bundle. In Smith and Leicester Health Authority, the court resolved the difference in favour of the Forbes test. What would the reasonable person have done placed in the situation of the plaintiff? And accepted that individual characteristics which might distinguish her from the reasonable woman should be taken into, should be disregarded. She talks about a number of cases in which different decisions have been reached. She then says at 87 on page 78 of this bundle, there is a related difficulty. A wording virtually identical to that in section 14.3 appears in section 14a10, dealing with constructive knowledge in a negligence claims for latent damage or other economic loss. There is no equivalent to the section 33 discretion for such claims, but there is an overriding time limit under section 14b. Both features would support the more generous approach to constructive knowledge. So in other words, given that even if you never acquire actual constructive knowledge, under section 14b of the Act, 15 years after the date of causative breach of duty, your claim will be time barred anyway. In Baroness Hale's view, that suggests that a more generous approach should be adopted.
It's 91 and 92 really is...
Yes, I'm just trying to get... Yes, thank you. So, my Lord, thank you. Paragraph 91. All the cases which have been referred are explicable on the basis the law expects people to make such inquiries, seek professional advice as they reasonably can when they have a good reason to do so. Their motive for not doing so will generally be irrelevant, but I would not want to rule out their personal characteristics may be relevant. There is a distinction between those personal characteristics which affect their ability to acquire information and those which affect one's reaction. Skipping ahead, it will all depend on the circumstances in which they find themselves, and so on. So a number of different views expressed, but Lord Hoffman in particular talks about the consequences, and this goes back to the 1974 Law Reform Committee reports, of the injury itself. That if they would reasonably inhibit them from seeking advice, that is a factor which must be taken into account. So I draw the analogy that the injury...
Sorry, that was Lord Hoffman where?
Sorry, this is paragraph 49, page 70 of the bundle report. Third line of paragraph 49.
But the injury wasn't caused by the alleged negligence here, was it?
Well, he had untreated dyslexia, and I will go back to the facts again, but he certainly I think that is what Lord Hoffman is referring to in terms of the injury.
Which is the failure to diagnose the
Failure to
dyslexia,
diagnose it.
presumably. But they were talking there about something different from this situation. I understand you want to apply by analogy. What they're saying there, say for example, he had been rendered deaf and blind,
Yes.
and it took him a year to get Braille. Then you could quite see why a person in those circumstances would take longer, and you could quite see why you talk about the injury. But here you're talking about a woman with £1 million claim, million plus I think it is, and hasn't taken action for 2 years because of the need for money to instruct the solicitor. There'd have to be very, very strong evidence, wouldn't there, that she was unable to take the necessary steps to get the advice to see what the problem was.
So in terms of, well, there certainly would have to be evidence. In terms of the evidence, that is dealt with. It was dealt with to an extent in the original witness statements, and then it was dealt with in greater detail in the additional statement produced in the December application bundle, which the parties have agreed should be admitted.
Anyway, so your argument is, within your sequence, I'm sorry, you say that the judge's only decision was that you couldn't have regard to finances, and you say that's wrong, and then there is the question of what do we do then, whether we do it or send it back.
Indeed.
In fairness to your case, that's your case, isn't it?
That is my case.
Yeah.
And perhaps we don't have time to take you through this in detail, but the judge discusses this issue in depth in paragraphs 45, 60, 61. At paragraph 61, though, I think we should look at paragraph 61, please, which is where he says, the judge said, in my judgment, all three appellate decisions, he's talking about Gravgard, Golston and Forbes, make it clear that a claimant in seeking to postpone the starting date under section 14A10 cannot rely upon personal circumstances which would not apply to some other person in the same position, and then in parentheses, as a potential claimant in respect of the damage suffered. Now that's an interesting phrase by the judge, because he appears to be saying that you can't apply on purely personal circumstances, but the corollary of what he's saying here is that you might be able to rely on circumstances that would apply to some other person in the same position as a claimant in respect of the damage suffered. In other words, an impecunious claimant. Now, in my submission, he then goes on to deal with 64 Gravgard, 65. He says at the third line of 65, in my judgment, it's contrary to the general thrust of the authorities, which are to the effect that the claimant's personal characteristics should be ignored. The individual claimant's financial circumstances are necessarily personal to him or her, and so on. He goes on to say, so far as any causal link between the claimant's impecuniosity and alleged negligence of the defendant is concerned, any inquiry into that would necessarily be taking place beyond, or certainly towards the end of, the ordinary six-year limitation period. And then over the page at 69, there is more discussion, but 69.
Well, 65 is important too, isn't it?
Well, that, yes, I was just quoting from that.
Oh, sorry, I missed that.
Sorry. I was saying that although the subsection is unclear on the question of wherewithal, seek expert input, I'm not persuaded by that submission. That's my submission. In my judgment, it's contrary to the general thrust of authorities that personal characteristics should be ignored. But his central reasoning for that begins at the end of 65, an inquiry into impecuniosity and the link between impecuniosity and the negligence would necessarily take place beyond or towards the end of the 6-year limitation period. And then over the page at 69, he says, I cannot accept that where a claimant relies upon impecuniosity for not having sought expert advice before a certain point in time, or on any such imponderables pertaining to the claimant's actual circumstances, are matters for argument in relation to a period potentially as long as the 15-year long stop. And that's the point that I think I mentioned earlier, that the judge then returns to several times in the judgment. At paragraph 163, at the end, right, I took your lordships to this earlier, where paragraph 163, the judge said such conjecture about the vicissitudes in the claimant's financial position over the potential period of 15 years provides a clear indication that wherewithal or a lack of it is irrelevant to the inquiry. So the judge's central reasoning appears to have been, it's unclear from the authorities whether or not I can take it into account, but the fact that it would be very difficult to establish whether or not there was impecuniosity during the relevant period, and potentially a causal link between that impecuniosity and the original negligence complained of, means that it's unlikely that Parliament could have intended that to be taken into account. But as we've seen in the Adams judgment, that is not necessarily the case, and indeed the House of Lords appears to have considered that Parliament may well have wanted inhibiting factors at least resulting from the original negligence potentially to be taken into account, and certainly the judge in this case appears to have acknowledged in that earlier part of his judgment that potentially the position of the claimant caused by the damage complained of could be relevant.
Isn't paragraph 69 against you in saying that Ms. Kay's impecuniosity was caused by the negligent advice? Because he says she might have taken up remunerative employment in 2014 and have been able to pay for expert advice herself. So it was her choice not to do that, rather than negligence back in 2008, which put her in a position where she couldn't afford to go to council in 2018.
Well, he does say that there, my lord, but then we go back to 162, which we've looked at earlier. There is his assumption, at least, that he's prepared to assume that her own financial resources were, throughout the 15 years from April 2008, as stretched as she says they were in 2018 and 2019. So having made that comment about whether she might have gone back to work, he seems to have considered in the end that, or at least accepted for these purposes, that she was.
Well, that's because he's prepared to assume impecuniosity and then say it's irrelevant. But if it is relevant, then where do you find a finding on causation that her impecuniosity in 2018 is caused by negligent advice in 2008?
Well, he has made no finding on
No.
causation. So,
And on the contrary, he said, well, she could have gone back to work and had remunerative employment.
if I may say so, a rather throwaway part of the judgment just there, having otherwise apparently accepted that she was without funds, and
well, having thrown it away in 69, he comes back to it and picks it up again in 162.
But having picked it up again, he immediately says he's prepared to assume that she's telling the truth effectively about her stretched circumstances throughout the entire period. So he doesn't appear to have made a finding that she was not impecunious at any relevant point, and that was not caused by. He doesn't seem to have found one way or the other. Potentially, is the ultimate position.
The oddity is he starts his legal principles at 21 is partly the way he written the judgment. He sets out all the legal principles, then he does the evidence, and then he applies it. And 21 to 69, his analysis of the legal principles and the application.
Yes.
And it does look at 68 to 69 at that stage as if he's saying it would be inappropriate to use impecuniosity, and in any event, there's no there's a real doubt as to whether or not he wouldn't have paid for it earlier. And don't you have to show that she could not? And the fact is, he did pay for it at some stage, and did pay for other things at other stages. So how is it that she's able to demonstrate that she has taken all reasonable steps by not paying for it earlier?
Her evidence was that she did, in fact, she was in fact impecunious throughout the whole period, and that it was a consequence of the way in which matters ended up with her ex-husband. And her, in the supplemental bundle, your Lordships will find her witness statement. Now, she doesn't go into it in great detail, it's fair to say, but she does go into it. Page 119. Well, that's where it starts. So at page 126, she discusses post-settlement events, paragraph 45 onwards, and talks about initially about the advice in late 2008, and then at 49, she talks about the problems that materialised with Manor Cottage, a full matrimonial home, and then over the page, she says she was forced to sell Manor Cottage in 2009 at a reduced price, as her ex-husband had threatened to take her to court. Sale completed August 2011. I was in the financial position where I could have taken over the mortgage if he cooperated, but left with no choice to sell because he wouldn't. They were threatening to repossess. And then there was minimal child maintenance. By 2011, there was no maintenance. And then, between 2017 and 2018, it became increasingly apparent, living an affluent lifestyle, that he was, leading an affluent lifestyle. There was issues about boarding at Repton School, at paragraph 54, issues with her ex-husband, and so on and so forth, about boarding fees.
In the 57, the last sentence, this is the bit that was corrected or changed in evidence to say that she could have got money from her parents. That was not in fact correct.
I'm sorry, Milo, which part?
Last line of 57. That was something that wasn't correct, I think.
Well, I'm not sure that was the evidence actually.
Oh, right.
I think the evidence actually was that her parents had been defrauded towards the end of 2009. But it's not the case that. So yes, so I suppose it's. Yeah, so what she was saying there was that back in the original ancillary relief proceedings, she could have borrowed money from her parents to fund investigations into Mr. Mahan's assets. And her evidence under cross-examination, I recall, from the transcript, was that it was towards the end of 2009 when the fraudster started to take money from her parents.
Okay.
So, yeah.
And then at 62 it says that you've been pursuing a court action.
Yes.
Around 2017, 2018 by the looks of it.
Yes. There are all sorts of things going on, which I mentioned earlier, but of course those things are of themselves not particularly relevant.
There's nothing about, I didn't have the money to pay, and doesn't she have to show that she has not failed to take all reasonable steps?
I think there is, but I will take a moment.
The 69.
We've gone past the quarter past, Mr. Hall.
Yes.
So this would be the moment normally to stop. I assume that bar sorting this out, you're really at the end of your submissions.
I think I was nearly there. I was going to say that in any event, if this statement and the answer in cross-examination were insufficient evidence, and I was going to make the point that in fact what the defendant's case was that she acquired the knowledge, if not in 2008, 2009, then instead in 2017, 2018. I don't think it was put. The defendant's case wasn't that, for example, in 2014 she should have gone and got some advice at that point. So that is why the focus of the evidence was on the earlier period and the later period. So that may go some way to explain why there's a relative lack of evidence about the intervening period, in particular point 2014, when the judge says she could have potentially gone back to work. So, sorry, I wanted to make that point while it's fresh in my mind, but there is...
I'm obviously concerned that Mr. Wilton should be able to get going
I understand.
promptly in the morning. So, if we stop more or less now, what would there be left in your case to deal with?
Not much. I've already, I think, addressed ground 8. I haven't taken you to the relevant parts of the judgment, but it's quite clear from the evidence that between February 2019 and July 2019 there wasn't a delay, which my submission was not my client's fault. I think there were just 1 or 2 points left, frankly, on grounds 5, 6 and 7 in relation to the judgment.
If you had 15 minutes in the morning, would that suffice?
Yes, it would.
Mr. Wilton, can you live with that?
Live with that.
In which case, we'll stop now. We'll start again at 10:30 in the morning with the 15-minute cut-off.
I'm very grateful.